Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about language rights. Cases that should have gone to the Supreme Court of Canada, but didn't. Raymond Carby Samuels filed a human rights complaint, and during the course of the human rights proceedings, he wanted to represent himself in the French language, whereas the people that he was filing the complaint against were dealing with the case in the English language. The Human Rights Tribunal ordered that the matter proceed in the English language. Mr. Carby Samuels asked for assistance to provide translation and for the state to fund an interpreter and translation services for him so he could access the Human Rights Tribunal in the language of his preference. The Human Rights Tribunal denied the application. He sought leave ultimately to the Supreme Court of Canada, who denied the leave application. And this case raises very important issues of language rights. We've often seen in criminal and quasi-criminal proceedings a requirement that the state provide translation services, whether it is in providing translation services for people who are being charged in English but who are having their trials in French and to assist them with having translation for counsel of choice, or to have translation services so that they can understand the proceedings against them if they're in another language. And those translation services aren't just limited to the English and French rights that we have in Canada. They're also available if you're charged with a criminal offense. An interpreter is available to you in any language that you speak in order to make sure that you understand the proceedings. Human rights proceedings are obviously initiated by the individual who's claiming that their rights have been violated, but they are still part of a state-run apparatus for dealing with human rights that are protected under state legislation. So should the state not be responsible for the cost of facilitating translation in a process that's meant to deal with your core inalienable human rights? And certainly your language, your ability to communicate, your identity as a French Canadian, for example, are all part of this human rights apparatus. So should not the tribunal be responsible for providing you with interpretation and translation services? And shouldn't people have the right to engage with the tribunal in the language that they speak, rather than the language of the individuals that they are claiming violated their rights? These are all very important questions that the Supreme Court of Canada should have answered. Language rights shouldn't begin and end when it comes to criminal trials. Language rights are something, particularly for the English and French language rights issues, that need to be addressed across Canada and ensure that people actively and are capable of participating in their court cases and their tribunal cases. And the increased use of tribunals across Canada, especially in provinces that aren't necessarily automatically bilingual, like Manitoba and Quebec, makes it more difficult for people who are Francophone or from the Francophone community to access justice through the tribunalization. The Supreme Court of Canada should have recognized the way that governments effectively are limiting people's language rights, which itself is a violation of their rights, by using tribunals to deal with significant and important legal issues. Hopefully the Supreme Court of Canada gets another opportunity to address the way that language rights arise in tribunal proceedings and really correct this significant problem. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.